Honorable Chairpersons and members of the Joint Committee, I appear before you today to vehemently oppose the Protection of Sovereignty Bill 2026 in its entirety. While cloaked in the language of patriotism, a careful legal analysis reveals that this bill suffers from fatal constitutional defects, including unjustifiable limitations on the fundamental rights, dangerous vagueness, and an unconstitutional subversion of the multi-party dispensation. In our current political climate, where the state keeps persecuting people and state persecution has forced opposition leaders and critics out of the country, this bill ceases to be a theoretical threat. It is an immediate existential danger to political pluralism, economic survival, and Uganda's standing in the global community. To appreciate the gravity of this bill, I invite the committee to examine the chilling day-to-day realities that this law will create across all sectors of Uganda if passed. 1. Reclassifying Ugandan citizens as foreigners. The most insidious provision is hidden in Clause 1, which defines a foreigner to include B, a Ugandan citizen residing outside Uganda. There are numerous Ugandans who live in the diaspora, and they remit over $2.5 billion annually to our country. All these citizens are going to be deemed foreigners by this law. When did this government cease to care about its citizens to the extent of regarding them as non-citizens? Consider a political leader born in Uganda, a registered voter, and a duly elected party president who is forced into exile or out of the country due to state persecution. Under Clause 1B, the moment that citizen crosses the border to save their life, that law strips them of their Ugandan identity and reclassifies them as a foreigner. Because Clause 1 defines an agent of a foreigner as anyone who acts under the direction or control of a foreigner, and Clause 2.2a says the act applies to anyone who engages in political activities, for or in the interests of a foreigner. The domino effect is devastating, Honorable Chair and members. Imagine a party official in Kampala receives a WhatsApp voice note from this party president who is out of the country, instructing them to coordinate some party activities. Under this bill, by following those instructions, the party official here in Uganda is guilty of engaging in political activities for a foreigner who left the country. Under Clause 14, they face 10 years in prison. Under Clause 5.4, they face 20 years in prison. A local party administrator or aide, simply doing their job by taking instructions from their leader, becomes a felon. Let me talk about the direct assault on the Political Parties Act and the multi-party dispensation. Articles 71 and 72 of our country's constitution, the grand norm, guarantee the freedom to form political parties, operationalized by the Political Parties and Organizations Act. The bill violently contradicts this act. Millions of Ugandans live abroad. Suppose a Ugandan doctor working in London pays $100, roughly 380,000 Uganda shillings, into the bank account of his local political party in Kampala as membership dues. Because the doctor in London is considered a foreigner under Clause 1B, the local party treasurer has just received foreign funding. If this pushes the party's annual foreign funding to over 20,000 currency points without the minister's approval, the treasurer of that political party faces 20 years in prison under Clause 22, and the funds are forfeited to the state. This is not right. By placing a cap on foreign money, which includes diaspora remittances to parties, the Minister of Internal Affairs is handed an absolute veto over opposition party financing. If the minister dislikes an opposition party, he simply refuses the written approval for their diaspora funding. The party is financially suffocated by state fiat, directly violating our country's constitution. Let me talk about the unconstitutional overbreadth and vagueness of this law, this bill. The legislative drafting of the bill fails the constitutional test against vagueness, granting the executive arbitrary power to punish dissent. is the catch-all foreigner. Clause 1E allows the minister to declare any person, institution, or body a foreigner. Suppose a local trade union stages a strike demanding higher wages, embarrassing the government. The minister can simply sign a statutory instrument declaring that trade union a foreigner. Overnight, the union leaders become unregistered agents of a foreigner and they face immediate arrest. How can this be right? Clause 22H states that the act applies to anyone who influences the public to oppose the policy of government. As the leader of the opposition, my literal duty and the team that I work with is to oppose government policy that is injurious to the citizenry and offer alternative policy positions, which we do every so often. A local civil society group running a radio talk show explaining why a new tax is harmful could be jailed for 20 years. That's problematic. I bring in one or two examples: the Russian and Chinese blueprint, importing authoritarian toolkits. This bill that we are discussing is a copy and paste of the most oppressive foreign laws adopted to liquidate any opposition to government. The Russian precedent. Russia's foreign agent law, which is mirrored in our clause 21, was used to stigmatize NGOs and jail opposition figures like Vladimir Karamazov for 25 years for opposing government policy. Clause 5.4 imports Moscow's playbook to Kampala. There is also the Chinese precedent. Clause 3.2 designates a department responsible for peace and security, that is ISO, as the entity to register agents of foreigners. This mimics China's overseas NGO law, which placed the Ministry of State Security in charge of all NGOs. Handing ISO, in our case, this power means opposition politicians and NGO workers, many of whom I see in this room, will not face auditors. They will face intelligence operatives. Now, let me talk about decimating the NGO sector and humanitarian response. Clause 22 restricts foreign funding to 400 million Uganda shillings annually without ministerial approval. Clause 7.4 makes it a crime, which could fetch one 20 years in jail for an agent of a foreigner to develop a policy without cabinet approval. Consider a local NGO fighting HIV and AIDS. They rely on partnerships with the Global Fund or World Health Organization, which are defined as foreigners under Clause 1. If local doctors sit down with these partners to draft a new national HIV treatment policy and present it to the Ministry of Health without first getting cabinet approval, the local doctors will have committed an offense under Clause 7.4 and could face 20 years in jail. There is the global precedent of India and Ethiopia. India used one of its laws to cancel the licenses of 20,000 NGOs, including Amnesty International, causing a massive collapse in humanitarian aid. Ethiopia's similar law decimated its civil society before they were forced to repeal it. Uganda cannot afford to scare away every international health, education, and refugee support organization, because that's what this bill would be doing. Economic self-sabotage leading to mass unemployment, scaring off foreign investors, and hurting Uganda's brand. Beyond politics, Honorable Chair and members, this bill is an economic suicide note. It creates a hostile environment for capital and labor, directly worsening the severe economic pain already biting Ugandans. That's why I'm calling it an economic suicide note. Legislative cruelty in the face of the USAID crisis. Honorable members, we are currently reeling from the recent withdrawal of the USAID support, which has pushed thousands of Ugandan health workers, implementers, and NGO staff into immediate unemployment. Families are failing to pay school fees, mortgages are defaulting. In this exact moment of crisis, this bill proposes to classify every remaining foreign donor as a foreigner, capping their funding at just 20,000 currency points without a minister's stamp, and threaten local NGO staff with 20 years in prison. To pass this bill now is an act of legislative cruelty. It guarantees that the European Union, Gavi, the Global Fund, and private foundations will look at the 20-year jail terms for local staff and withdraw entirely to avoid legal liability. That's what will happen. The thousands already rendered jobless by US aid will have absolutely no hope of being reabsorbed into the sector. This bill will deepen the unemployment crisis exponentially, criminalizing the private sector and foreign investors. A foreign mining company or manufacturing plant operating in Uganda is a foreigner under Clause 1D. Under Clauses 7 and 10, if that company's local Ugandan CEO or legal counsel advocates to a ministry for a specific regulatory framework, for example, tax breaks for manufacturing, they are deemed to be influencing the development of government policy on behalf of a foreigner. They face 20 years in prison. No serious foreign investor will bring capital to a country where legal advocacy for their business interests is criminalized as foreign interest and interference, stigmatizing every Ugandan in formal employment. Clause 1 defines an agent of a foreigner as an employee or servant of a foreigner. This means every Ugandan working for MTN, Standard Chartered Bank, Toyota Uganda, the UN, or any foreign embassy is technically an agent of a foreigner. Under Clause 14, they must register with ISO. If their employer inadvertently runs afoul of these vague regulations, the Ugandan employee will go to prison for 10 years. To mitigate this massive legal liability, foreign companies will simply stop hiring Ugandans in senior roles or pack up and leave entirely, destroying Uganda's brand abroad. We are currently, as a country, negotiating with the IMF for debt relief and positioning Uganda as an investment hub. If this bill passes, global headlines will read, Uganda passes Russian-style foreign agent law, jails citizens for talking to exiles. Investors do not read the fine print of our clauses. They look at the headlines and move their billions to Kenya, to Rwanda, or Tanzania, or elsewhere. This bill makes Uganda look like a rogue state, and it pains me to say that, jeopardizing our trade preferences under AGOA and the EU. Let me address gagging the media and paralyzing the financial sector. This bill weaponizes vague economic and security terms to paralyze banks and silence journalists. Clause 13 criminalizes economic sabotage, publishing information that weakens or damages the economic system. Suppose an investigative journalist publishes evidence that a senior government official stole 50 million US dollars from the National Treasury. International investors panic and the shilling drops. Under this bill, the government can arrest this journalist for economic sabotage and jail them for 20 years. The crime of this journalist becomes exposing the theft, not committing it. And yet we should be encouraging everybody who has capacity to expose corruption and to bring it to the fore such that it gets punished. After all, the IGG told us we lose 10 trillion shillings to corruption every year. That's money we should plow back into the economy. Weaponizing commercial banks. Clause 25 dictates that a bank cannot pay out money to an agent or foreigner without proof of ministerial approval. If a bank fails to do this, they face a civil penalty of 200,000 currency points. That's 4 billion shillings. No bank CEO will risk this. They will preemptively freeze the accounts of opposition figures, NGOs, and media houses out of fear. The state won't need court orders to freeze opposition accounts. The bank will do it for them, given this law. Let me end with legal redundancy. We seem to be trying to solve a non-existent problem. The memorandum of the bill falsely claims that there is no specific law upholding the sovereignty of the country. Legally, this legislation is entirely redundant. If a foreign embassy tries to fund a violent coup, for example, the Penal Code Act already criminalizes treason, which is punishable by death. If someone launders illicit foreign money, the Anti-Money Laundering Act already mandates declarations of source of funds. If foreign funding goes to government institutions, the Public Finance Management Act already strictly regulates that. If NGOs, many of whom are in this room, flout the law, the NGO Act already provides for a framework of sanctions. The only gap this bill fills is the loophole that currently prevents the state from classifying an exiled Ugandan opposition leader as a foreigner, to bypass the Political Parties Act and jail their local supporters. The conclusion and prayer. Honorable chairpersons and honorable colleagues, as you draft your report, I entreat you to visualize the kind of Uganda this bill creates. A Uganda where a citizen out of the country is stripped of their nationality. A Uganda where a party treasurer goes to Luzira for receiving membership dues from a Ugandan in Saudi Arabia. A Uganda where thousands of already unemployed US aid workers watch their remaining colleagues flee the country rather than face 20 years in jail. A Uganda where a foreign investor's local lawyer goes to prison for drafting a policy memo. A Uganda where international NGOs flee, taking our healthcare and refugee support with them. Passing this bill will not protect Uganda's sovereignty. It will kill the multi-party dispensation, plunge thousands more Ugandans into absolute poverty, chase away foreign investment, and turn our country into an international pariah. And I hasten to add, clearly this bill is intending to stifle dissent. This government, in my view, should be excited to receive criticism from political leaders, from civil society organizations, from members of the general public, because they are all stakeholders. When we say healthcare is grappling, when we say there is corruption, that should not be a bad thing that warrants a whole bill to try and stifle that dissent. Government should listen to those concerns of Ugandan people so that it can improve, so that the taxpayer money that is given to government is put to good use. Any serious government should have that at the back of their minds, as opposed to finding ways to shut people up. That's not right. In light of the foregoing, I respectfully pray that your joint committee recommends the total rejection of the Protection of Sovereignty Bill 2026 in its entirety. I beg to submit.
A consensus on conceding to certain parts of the bill, and he threw it back to us, as it is indeed our responsibility to sanitize or cleanse where spots of dirt are envisaged. From your submission, and in conclusion, you invite this committee to reject the law in entirety. And one of the highlights you make is the definition of a foreigner, which the move of the bill also seemed to suggest that we can, it's upon this committee to review where we find it inappropriate. So in line with that, in case an option for total rejection of the bill is not one of the options available to the committee, and because we need to come up with a good law, I invite you to look at clause 2 on the application of the bill, where it applies to any person who acts as an agent of a foreigner, and then subclause 2, for the avoidance of doubt, this act applies to an agent of a foreigner who engages in any of the following activities through any means. This seems to suggest that it's not a blanket application, and the activities are there listed. Right Honourable, are you open to having a discussion on how to improve some of these provisions, or you still stand by only one position, that the law in entirety should be rejected? And should you have another option to improve some of these provisions. What is your take on the application of the bill, specifically on clause 2, subclause 2? Thank you.
Thank you for the presentation. I wanted the Right Honorable Lope to look at Political Organizations Act. What does it state about foreign funding? And if it is very clear that it doesn't include subscription fee, what would be your take? Because actually the bill is brought to us either to throw it out, do enough surgery, and you know the process the bill takes before it is eventually enacted into law. We do a lot of surgery and refining. How would it be? Then secondly, ISO. You say ISO, is it housed in Internal Affairs or in the President's office? Because in your report, you are clearly stating that it gives the mandate to ISO. And in the bill, this is a committee or a body that will be housed in the Ministry of Internal Affairs. I wanted you to really elaborate ISO in Internal Affairs or ISO in Presidency. Thank you.
Thank you, Honorable Keo. I think that's fine. We can.
I'll begin with the one of Honorable Kai. Political Parties and Organizations Act regulates activities of political parties. And so everything about political parties is encapsulated therein. Your question about ISO is Internal Security Organization. And in their modus operandi, they work alongside the Ministry of Internal Affairs. So that's the nexus there is. Honorable Taylor mentioned that the movers of the bill, Internal Affairs and the Attorney General, seem to concede on a number of provisions. So I think what you're saying is, would it be okay maybe to alter some of those as opposed to total rejection? I think I'll tie that in with the last question about my remarks referring to this bill as legal redundance. As I mentioned earlier on, we have a plethora of laws that capture the critical concerns that government would have, whether it be anyone flouting any law in as far as the relationship between Uganda and any other country is concerned, somebody out of the country and so on. I mentioned them. Anti-Money Laundering Act. The Penal Code Act captures a number of those provisions. And that's why I'm saying that this particular bill is irrelevant. The good lawyers, the majority of the members of the committee are lawyers, including the leadership of the committee. It is not helpful when you keep putting together pieces of legislation over things that are already taken care of. Again, you cannot have an act of parliament for anything and everything. Each act of parliament will encapsulate numerous issues. But the assertion that for anything and everything we must have an act of parliament, that means parliament would be sitting every single day to pass like 50 bills every day, which is not helpful. So my insistence is that we already have adequate laws that cover anyone that would bring in money into Uganda illegally, anyone that would trade outside of the law, anyone that violates any law in this country. None of us is above the law. Just because you're a member of parliament does not mean you cannot commit an offense and be taken on by the law. Should we now have a bill entitled an act of parliament legislating how a member of parliament gets arrested and arraigned in courts of law? Because a member of parliament is a citizen of Uganda. The Penal Code Act captures how any citizen who is assumed to have committed an offense gets to be arrested, taken to courts of law. Whether you are an ordinary citizen, whether you are a military person, whether you are an honorable member of parliament, and so on and so forth. So we cannot have a bill now for, this one is for members of parliament, this one is for councillors, this one is for ministers, this one is, you get the point I'm making. So that's really my general feeling. So it's redundant to that effect. That even when we alter and say, as the Attorney General is saying, okay, we can change the meaning of a foreigner so that Ugandans in the diaspora are not considered foreigners. So didn't these people prepare in their legislative drafting? Why did they not foresee that? That is very problematic. And that's why we are saying this bill is irrelevant, because the intention is not really the law. That's why now they are quickly conceding and saying, okay, let's adjust this, let's adjust the other. Clearly showing it is not relevant. We already have got a plethora of laws that provide for any breakage of any law by a Ugandan here or a Ugandan in the diaspora. The other day, Dr. Kizza Besigye was abducted from Kenya and brought here. They said he had committed an offense in as far as Uganda is concerned. Fair enough. Of course, what we have been saying is, can he have due process? Which has not yet happened. But he was picked up from Kenya. Is there any law? Yeah, they are referring to a number of laws already in place. Penal Code Act and so on and so forth, Anti-Terrorism Act, and all of the others. What we are saying, of course, is let due process happen, try the man instead of being fungible all over the place. So I don't think, honorable colleagues, that we need to enact a law for literally everything. So in finality, again, I would like to entreat this committee. Let's not be seen to strip the people of Uganda of their sovereignty. The Constitution provides for the sovereignty of the people of Uganda. That sovereignty is not given by the executive. It is not given by this parliament where we sit, honorable colleagues. No. It is inherent and captured resultantly in our country's constitution. So that sovereignty is in place already. But we seem to want to take away that sovereignty, because sovereignty includes that as a Ugandan, I'm a stakeholder, I must be concerned about the happenings in my country. If I'm a taxpayer and I see my tax money is being stolen, I should have the right to voice out a concern and say Minister X, MP X is stealing my money. That should be my right as a citizen. But we seem to want to strip that away from them. Don't criticize. But why? They are stakeholders too. Why doesn't government want to be criticized? There should be no problem with that. But also saying that as a citizen, you are not supposed to critique government policy. Why? Because you see, we seem to now want to put it on paper that this government is authoritarian. That's what it appears to be, Honorable Chair. Because we are saying when government comes up with a policy, all of us must just oblige and follow. No citizen is supposed to critique it. But surely, what happened to participatory leadership? The people of Nyabushozi should have a say in whichever government policy you come up with, because they are stakeholders, they are taxpayers, you are their voice, and that goes, of course, for the people of Nakao West and whichever. We are their voice, but they should be able to participate. So when we sit in Parliament and come up with a law or a policy, they have the right to go on a radio station or to call into any program and say, I disagree with this government policy. But what this law is saying, when you criticize government policy, we are going to arrest you.
Which particular clause, law?
Honorable Chair, I have made my presentation, except if you want me to go back to it.
No,
I'm making my summary.
That criminalizes
that if you are pushing through a policy courtesy of a foreigner against government policy, that's what you seem to be saying. So if a Ugandan says, I disagree with this particular policy, then you say, no, you seem to be influenced by foreigners to oppose this government policy. Let's give the people of Uganda a free rein to critique, to share their views, to give their input.
Thank you.
It's good for leadership. I thank you.
Thank you.
Now, the Attorney General was here and clarified to us and said, we must pay attention to clause 2, because clause 2 in the bill is the scope of the bill. Because once you miss, according to him, once you miss clause 2, then you'll meander a lot. You'll meander a lot with a thinking that this bill, for example, is targeting everyone in the manner that has been discussed by some people. So according to the Attorney General, what he told us, this bill excludes, for example, NGOs in charity, in churches, excludes churches, investment companies, banks, multilateral organizations, family remittances, private remittances, law firms, business ventures. All those, according to the Director General, are out of the purview of this bill. So, Clause 2, Honorable Taylor was engaging your indulgence on whether, in the event that entirely rejecting the bill is not one of the options in the committee, how do you help the committee for us to be able to deal with Clause 2? Because Clause 2 also can be trimmed further for clarity. I'll give an example. You have just talked about government policy. Shouldn't citizens oppose government policy? Yes, citizens can oppose government policy. But if you oppose government policy for the interests of a foreigner, we cannot allow that. Why? Uganda decides, for example, to say, we are going to do irrigation using the waters of the Nile. And you know some countries have interest in the waters of the Nile. Uganda wouldn't, for example, want Uganda to utilize that water such that it can be able to flow to the Mediterranean. So, a country downstream, for example, funds against such a policy of widespread irrigation. So, these people who are opposing that government policy, because they have been funded by a country downstream, for example, would be promoting interests of a foreigner. So they are within the ambit of Clause 2. But the ordinary opposition organic opposition of Ugandans going about their work and opposing government policy or laws, that one is not within Clause 2. So I think myself, that whereas government seems to be interested in talking of adverse foreign policy, it is vulgarized. For example, the definition of foreign policy, foreign interest, is not so clear. So it is vulgarized. It could easily spill into even foreign policy which is friendly to Uganda. For example, an international NGO that is funding charity work, helping school fees to PWD children, vulnerable children. That one is friendly. Foreign interest, but friendly. The other one was subversive. It's not so clear in the bill, and I think we need to help the move of the bill, if that is his interest, because that seems to be the interest, that subversive foreign interest is what they are talking about, not just foreign interest, and it was not clear. So we need to be helped, that in the event that the option of throwing out the bill entirely is not there, how do we trim Clause 2 to ensure that there is precision and clarity on what exactly we are talking about?
To influence government policy in the interest of a foreigner, we cannot allow that. Those were his remarks. Those remarks have worried me because he's a co-chair of this committee. He seems to have taken a decision already, and so our presence here is irrelevant.
As a Ugandan.
That's very worrying.
Not as chair, but as a Ugandan.
You see, as chair, with due respect, you're supposed to be a neutral arbiter, because now you're intimidating all these people who have come to make presentations, because they want to make a presentation in opposition to the statement you have said. But now the judge is already passing judgment and saying, we cannot allow that. I want to request that we remain neutral, so that these people can share their views. Otherwise, when you pass judgment already, we can very well pack up our bags and go away, because you're just ticking a box. Also because, Honorable Baka, you see, Clause 2A, 22A, says engaging in the political activities in Uganda for or in the interest of a foreigner. And then Clause 1B, a Ugandan citizen residing outside of Uganda is a foreigner. But those Ugandan citizens, they remit $2.5 billion per year to their country. They come back home every so often. They've got business interests. They've got children they're paying school fees for. So if government passes an education policy, why don't you want them to oppose it? Because they're interested stakeholders. Their children are going to school here in Uganda. And so we should be concerned and capture all of these issues. Finally, again, Honorable Baka has said, in the event that throwing the bill out is not an option, why isn't it an option? Why are you ruling it out, Honorable Chair? Because This committee is clothed with all of those powers. Committees have thrown out business of government several times. In fact, even today on the order paper, there are some which are meant to be withdrawn. So there is room for that. Kindly don't create an impression that this bill is a do or die. It has got to pass. You have got the authority. Just to remind you, you're a senior lawyer, you know, as a committee of parliament, this bill is really at the whims and fancies of this committee. This committee can choose to say, government, we don't agree with this bill, we have thrown it out. Except if you want to say you are on gunpoint. I don't believe you are. I don't believe you are. So please don't make a statement to say that in the event that throwing the bill out is not an option. Let's give our views, and then the committee members will decide. What if they vote overwhelmingly to say, let's throw it out?
Honorable, I think you, so, with due respect, you meant to misconstrue Honorable Baka's statement.
Yeah, that's why
the reason for our being here is that we are open to receiving all the views. Please? Yeah. Okay.
Most obliged. So I just, because as a colleague we can share, to say, these people here who don't know how to operate, they might think now it is finito.
Right Honorable,
it is only how
they are saying,
and without prejudice.
Declare me as the elected winner, but in the alternative.
Yeah, but you see, as a petitioner in court, you can choose to say, for me, this is my only prayer. And then court decides. So court should not say, no, you cannot have just one prayer, but I'm the one coming to court, so I can choose to have just one prayer. I thank you, Honorable Chairs and colleagues.
Let me make a comment.
Thank you. I think we applaud the lead of
my relatives who are abroad, and in some circumstances, I'm expecting tuition as well. So days reach whereby exams are approaching. I clearly need the tuition. The bureaucratic procedure, which is clearly listed in the bill, makes it very hard for me to get the tuition. Why? Because at the end of the day, I have to first give in my reason, and I have to get declaration before I can withdraw these funds. And also, if at all I'm to get the scholarship and I go to do my master's in another country, I lose my citizenship.
No, you don't.
Because it states that it defines me as a foreigner. It clearly defines me as a foreigner in the sovereignty bill.
No.
Then also, and for some circumstances, if at all I plan to work abroad to study, I lose full participation in Ugandan affairs, and as well, my connection to Uganda becomes legally a bit weaker, and also the Constitution clearly states that power belongs to us, the people. But the bill makes us the citizens to clearly seek permission before we act on anything. And it gives final authority to the government officials, which shifts the sovereignty from the people to the government entirely.
You have, yes, not at all. And nobody
if any creative, commits criminal offense, they are dealt with like any other citizen,
yes,
Ugandan citizens. And the funny thing, just like the leader of opposition mentioned earlier on, some of the things the bill is talking about are already catered for by other laws that are existing. So what are we saying? The way the bill is set, it's sabotaging the creative space that is just developing, that hasn't even started working. Just like it's been mentioned, and good enough, we have a detailed document, apart from the oral that he's been reading.
No,
we have another detailed document with the specifications.
Where is that?
It's
the one that's attached?
Yes, it's attached.
We have seen it.
That has detail.
Okay,
we have even that the recommendation can be detailed
close by close
to the detail. So what are we saying? We are not saying this bill should target certain people.
Not at all.
But as they bring it, we are in interest of government formalizing, working on its system for everything to be perfect. But in the same spirit, it should not break what exists.
Okay.
Yeah.
Good. I think this...
He did ask that, are there any creatives that are agents of foreigners? I want to say in the affirmative, yes. No. That is why we are here to say that the bill in its current text In the affirmative, it is a yes.
Okay.
Yes. Because from where I stand, as a collecting society, UPRS, we work through reciprocal agreements where we sign with other collecting societies of other countries
Yes.
to collect on our behalf where our music is being played, Ugandan music is being played. And then
as you also play theirs.
Yes, as we also play theirs. So they have to send us the money that they collect from their markets.
That's a very interesting.
In the current text, in the affirmative, yes, we are agents of foreigners, and we are saying that is not a fair ground.
We thank you for having come forward. We thank you.